Hi, everybody. Hello, we're going to wait a few minutes until more people join us. If you hear me, if you can see me, please write in the comments. Make me a signature or a heart or a like or something so I can know it's working. I'm going to try to log in from my phone as well, just to make sure everything is working well. Hello, Sandrine. I'm glad you're with me. For some reason, there's a delay. I see it on my phone, but I don't see it on. Oh, now I see. I see it on the computer as well, and I'm broadcasting from the computer. So welcome. If you would like to share this, I think there's an option to share. I saw it before when I did it. Not sure. We will wait a few more minutes to see if more people join us. We will wait a few more minutes. Hello, Avi. Hello, Deborah. Welcome. Welcome. I'm new to this. I've never done a live Facebook, so you have to be patient with me. Hello, Wendy. Nice to see you. A long time, Wendy. Welcome. I think there's a way, if you want more people from your circle to be able to watch this, for you to share from your page, from this page to your page. If you think that's something you would like to invite friends, or there's a button in my screen I see on the left side, and on my phone I saw before share or um, spread it to a page or a group or something like that. I'm trying to see how I can do it. So what I'm aiming to do is I'm aiming for an interactive lecture. That being said, I think it could be maybe a little bit hard because sometimes there's a delay between what I say and what I see you write. I would like you to ask me any questions. So if you can write your questions down, I will try to get back to them. And if I didn't for some reason, if I missed it or if it went by too fast, please send me a private message. You can either message me on my private profile, which is Liat Goldstein, or on my professional page, which is Liat Levari Notary. I will write it here. It's up in the description, so you can write me a message there. Um, Also, hello, Daphne. Nice to see you. Long time, Daphne. Glad to see many of my acquaintances and my friends. welcome. We'll give it a few more minutes because we said 6 and it's not 6 yet. I just wanted to make sure that all of us are in and people don't have a problem logging in. I promised before that we'll come early, and I'm trying to see how I can see it on a phone. In case some of you are watching on phones. Hi, Elena. Nice to see you, and thank you for commenting before when I did the testing. I had a few people who commented and helped me make sure it's going to work because I didn't want to do something and then not be able to see it. Okay, I think it seems to be working from my phone, so I'll put my phone away. Hi, Sharon. Nice to see you. Thank you for joining us. Great. So, like I said before, we'll give it a few more seconds so more people can join us, and I will start shortly. In the meantime, I want to tell you a little bit about myself. I am a notary for the past almost 4 years here in Quebec. Before that, I was a lawyer. I've been a lawyer for over 20 years, so I have a lot of experience in different domains of the law, and my specialties are varied. I do real estate transactions, mortgages, refinancing, etc., etc. But today I'm going to speak to you about the importance of having wills and mandates in Quebec. Why is it important? How many types of wills are there? Which ones are the good ones? Which are better? The advantages and disadvantages of each one. And at the end of the day, give you some advice on what you should be doing and how you should go about having a will. And if you have any questions, I said before, for those of you who are joining us now, please feel free to write in the comments. I will try to follow the comments as I go through with the live feed. If I don't get to it, then I will try to return the reply later on, or you can always message me either at my professional page, which is Liat Levari Notary, or at my personal page, which is Liat Goldstein, and I will try to answer you. I guess we'll wait 1 more minute and then I'll start. Whoever joins us later will be able to watch later and rewind. I'm just trying to see that everything works on the phone, because I was asked to share this link to other pages, and I want them to be able to access it. And I'm new at this live feed as well. I usually do frontal lectures, but in today's world, I found it could be easier for us to follow online, because all of us are busy, all of us have commitments, and it's not very simple sometimes to just join in and leave everything for a front lecture. I've been lucky enough to watch a few lectures over the past few years, and I found it a very effective tool. So I wanted to try it with you and see if it works. Everybody's here, and you can see me. Please write me if you can hear or see me. Okay, I guess we'll start, because we said 6 and it's now 6:04. Okay, so welcome everybody. Again, my name is Liat Levari. I'm a notary. I've been a notary for the past 4 years in Quebec, but before that I was a lawyer, and still I'm a lawyer in Israel for the past 20 years. So I have different experiences in different domains of the law. Today, I'm going to speak to you about the importance of having wills in Quebec and mandates of protection mandates, mandates in case of incapacity, or what a lot of people refer to as living wills. I will start with the will. So I'm going to try and ask questions, and I'll see if you can write your answers, and if we can do it like that interactively, like I do when I meet people in person. But if it doesn't work, then I'll just ask the question and give the answers. Maybe that way it will be more efficient. So who can tell me how many types of wills are there in Quebec? And if you know also what are they called, that's even bonus points. So I'm not sure if there's a delay between what I speak and what I hear. When I opened my phone before, I saw that there was a delay. If you can hear me, just click hi or something, just so I can see we hear or something like that. Can you hear me? I'm not sure if it works. Can somebody write me something? Oh, here I see. Okay, perfect. So you can hear me. Great. It's amazing. So I don't know if you heard the question, or if you prefer me, I will not ask questions and wait for your answers. Maybe that will be a little bit too much. I will just tell you the questions and the answers. So in Quebec, there are 3 legal forms of wills. All of them are legal, all of them are acceptable, and all of them are going to be binding and respect your wishes as the testator. However, not all of them are equal in terms of their advantages and disadvantages. The first will is the holograph will, which means a will that you handwrite on anything. It could be a piece of paper, it could be a post-it. Some cases in the law refer to some wills that were done on a Kleenex or a toilet paper, and all of them were legal and binding as long as they respect the formalities that the law established, which is handwritten from start to finish by you, and also at the end dated. If you did that and you established in the will, I, Liat Levari, am writing this will today on September 24th, 2019, and I wish to say 1, 2, 3, 4, and you sign it, it will be acceptable and binding. The problem with those wills are, A, they're not very preserved. So if you write it on a piece of paper or on a Kleenex or a Post-it or whatever, not necessarily that you will find it. And if you'll find it, the quality of the ink will not necessarily be good. And then somebody may not understand what you wrote, or the ink can be fading, or it could be destroyed, or there will be some kind of blemishes or water spills or whatever. So this is one disadvantage. And the other disadvantage is a very big one. It's after you die, this will has to be probated by the court and verified so that the court can establish that it was exactly you who said that and not somebody else, and those were indeed your last wishes. So those probate procedures take time and they cost money. And in today's term, I just read an article yesterday in La Presse that in today's terms, it costs between $2,000 and $3,000. And at the end of the day, until the court gives you a judgment that the will is probated, everything that you owned is frozen. Your family cannot benefit from anything. They cannot touch anything, not the money, not payments, nothing, nothing, nothing. And it take up to 6 months to get a will probate today. But the advantages is that it's simple, it's quick, and if you change your mind tomorrow, you can just throw this paper to the garbage and start over and write a new will and just, reword your wishes again. The second type of will that is probated, that is legal in Quebec, is a will executed before two witnesses. The witnesses have to be over 18 and of sound mind, and once they sign the will does not have to be handwritten. It can also be typed or computerized and then printed. Once it's probated, again, just like the holograph will, it is going to be effective and binding and respectful of your wishes. But like I said before, because you need to probate it until you get a judgment from the court, your wishes are going to be on hold. Everything is going to be frozen and nobody will be able to act, not the liquidator, not your beneficiaries, not your family members. Everything will be on hold until you get the judgment from court. Which leads me to the third kind of will, which is a notarial will, where you come and see a professional notary and the notary gives you legal advice and he works with you on what it is that you need on per case-by-case basis, and they together, you and the notary, create your will and insert all different kinds of clauses for who will be your liquidator, clauses that pertain to guardianship of your children if you have minor children, and of course clauses about how you wish to dispose of your assets, who will get what, if you want to give something to charity, if you want to give a particular item to a particular person, and what do you want to do with the rest of your property. The notary also helps you do financial planning. So in case of a possibility to maximize gain and avoid fiscal impacts, the notary sits with you and explains to you on that, and so forth. The advantages, other than what I just said, is that the moment the person dies and the will that is established is the last will that was done with a notary, the liquidator can start acting right away. All the bank accounts are unfrozen. This can be maybe a month or something like that can happen. But after that, it's active and you cannot, you don't meet any delays and you can act right away. Are there any questions until now? Just write me if there are any questions, if something is not clear, because I see your answers, but I see them with delay. I'm not sure if it's because of the computer and the internet here, or if I'll do it from the phone, it will be different. In the phone, I actually see it faster, but I think if I'll put the phone on the website feed, then I will be hearing feedback. Just let me see. I want to make sure. No, I cannot see it from here. Lectures over the past 2 years, and I find it a very. Yes, I hear it with delays. At any event, like I said, all three wills are binding. All three wills are going to respect your wishes. Some of them are less effective in terms of times and delays. And at the end of the day, you're pennies wise but pound foolish, because you are saving the money that you would see now a professional to give you legal advice and to benefit from the notarial will, but you're writing it on your own. You take two witnesses, but at the end of the day, you're going to spend, or your family is going to spend much more money once the time comes to probate it by the court. You will have to hire a notary or a lawyer to go with you to court to produce the evidence that is required and to get the judgment that is going to demonstrate that the will is indeed your last will. Now, what happens if a person dies in Quebec without any will? Not a holograph, not before witnesses, and not before a notary. What happens is that the person dies and their assets are distributed according to the laws of succession of the Civil Code of Quebec, which means if you are married and you had children, then your spouse automatically gets 1/3, and your children share between them the two remaining thirds. That's a very problematic situation, because even, let's say, a couple who is separated and about to get a divorce, but there's no divorce judgment and it's not final yet, you don't have a will, automatically your spouse will inherit a third of your estate, even if you didn't want him to, even if you were separated, even if you were determined to stay away from each other and to start a new life for each other, he or she will still get judgment is not final. The second problem that arises with the situation, if your children are minor, which means under 18, and if they don't have, sorry, if they're under 18, and if you want, as the adult, if you want to do something like sell, hypothecate, renew the hypothec, do anything like that, you cannot do it without going to court and having the court approve your will, your wishes, and establishing that for every child that is inherited over $25,000, you need to apply the court and follow a strict rule and regulations of how to do it, and the court has to approve at the end of the day. So even if you are the one who is the adult and you know best that now you have this big house and you're not able financially to sustain the house because your partner has passed away, you're not able to sell it just like right off the bat. You have to get your appraisal. You have to get a tutorship council for membership of the both families to have to say, yes, it is in the best interest of this child and that child, if there's no more than one, to sell or to mortgage the house, because the parent cannot do anything about it, and they cannot manage by themselves. So it's a hustle. It takes time. It takes a lot of money, and there are delays. And meanwhile, while there are delays, you can not do anything, not renew your mortgage, not sell, not even put the house for sale, because if you are and you have an accepted offer and you go through the notary, any notary will tell you they cannot pass the title because the court has to approve each share of each minor that is worth over $25,000. So if you there was a person that commented on one of my posts that I will do this live feed before, that she herself a few years ago, when she bought her house, she herself encountered this problem. They were the notary about to sign, and then they discovered that the woman who was signing was a widow, and her husband died without a will, and she and her children were the beneficiaries. And the person could not have moved on because the court did not approve. Nobody knew that they have to go and approve it, and the court said that they had to reconvene and go in front of the court and ask for permission to sell for each of the minors, and only then were they able to sell. But it took some time, and it was delayed because of that. This is about wills. I don't know if any of you have any questions before I'm moving on to the next topic. I heard a question, but I don't know where it was. Okay, moving on. I don't see the questions. There could be delays on your end. If I'll see them after, I'll go back and answer them. For the next part, I see that we're going to speak about mandates. Mandates are a document that are, no, I'll step back. The will starts after a person dies. So it doesn't matter what you wrote in the will, as long as you're still alive, you can change your mind a million times and you're not going to, nobody's going to act and carry your wishes. But what happens if you're in an accident or if you have dementia or Alzheimer, you're still alive and physically well, but you're unable to make decisions for yourself? What happens then? Are you able to get your spouse or your children to make decisions for you? The answer is to a partial degree, yes. Hospitals, residents, doctors will make family members of first relations, like next of kin, make certain decisions, but after a certain limit, which they decide, each hospital, each place decides for themselves, they say no. Does your spouse, does your mother, does your father have a protection mandate? If yes, go homologate it, do a procedure that at the end of it you will get a judgment naming you as, or somebody else from your family, as the person that's authorized to make the decisions. It's called a mandatory. And if they don't have, go to court and have somebody appointed to make those decisions. So again, the moment you have to go to court, there are additional delays and there are additional costs. But even if you do have a mandate in case of incapacity needs to be probated, which means a family member has to bring a medical report saying that the mandate, the doctor has examined the person and the doctor decided that the person is no longer able to make decisions for him or herself, and the decisions have to be made by somebody else. With that medical evaluation, we go to a social worker that's going to examine the person, speak to him, meet with family members, and then they will decide who is going to be the best person that is going to take care of the incapacitated person. With those two evaluations, you have to start a proceedings either before the court or before a notary that was accredited to do this kind of procedures. Not all notaries are. For example, I took a 2-day course with the Chambre des Notaires and I'm certified to do proceeding before notary. And there's a procedure that has to be done to start the homologation. At the end of the procedure, after, for example, I have met with the person concerned, even if he or she are not able to speak, or if they can speak, they don't speak clearly, or if they speak and it's clear, they don't make sense because of their medical situation. At the end of the day, after my conclusions, I have to submit them to court, and the court will have to sign off on the conclusions and get yourself a judgment naming that person as the curator or mandatory for the person, and give them the powers to act on their behalf and make decisions that are good for their health and decisions that pertain to their property. So for example, for the property, if that person lives in a house or in a condo and there are anything to pay like taxes, or if it's a condo fees, or to open your mail, or to do your taxes, or to do anything that relates to your property, to go to your bank, to access your accounts, to do investments, do different things like that, they will be able to do that with a judgment. Or if it's decisions about your property, about your health, you are no longer able to live in a private place and you need to be placed in a residence, or you need some kind of medical procedure or follow up with the doctor, or whatever you need to do, you have to make those decisions for the person that you have that you are going to take care of, because nobody else is authorized by the court by virtue of the judgment that you received. So, like we said, until you are dead, nobody can read your will, and it doesn't matter. Many people confuse the notions of a liquidator, which is the executor that takes care of your estate after you die, and the mandatory, which takes care of you as long as you're alive and makes sure that your money serves for you and for your benefit as long as you're alive. nobody can make those decisions for you. So people say, but I have a will and I named in my will my beneficiary, my liquidator will be my beneficiary as well, and he will take care of me while I'm alive. No, it doesn't work like that. It's not obvious that this is what happens. It's not obvious that your wife, your husband, your child, even though they're over 18, will make those decisions for you. In case of a mandate, somebody has to be appointed for you, either by you when you're still alive and well, in a protection mandate, or by the court if you didn't do that when you are alive and well, the court will have to appoint somebody upon a petition of a family member. Now, in order for you to be able to benefit from having to choose that person who will make the decisions for you, it's best if you choose that person and not leave it up to the court, because then you are not able to establish a clear guideline of what you want to do and how you want it done. And also, if the court has to name somebody for you, you don't know who that person will be, if that person will be a good fit for you or not, and it will take longer. So I'm wondering if anybody has a question. I don't see anything that you may write. I'm not sure why, but if you are able to just press something like a like or something, that I will see that people still can hear me. Don't see anything. Well, I'm hoping you can hear me. I see there are people who are watching. Okay. Also, in a mandate in case of incapacity or living will, you can also speak about end-of-life measures. So if you're at a, oh, here, now I see a like. If you are at an end-of-life situation, do you want to be kept plugged in a machine? Do you want to be subjected to treatments and surgeries and all sorts of chemotherapy and dialysis, even if there's no brain activity? Or would you like them to sort of plug you off and let you die? You can speak about that. You can also address organ donation in your mandate, whether you refuse it altogether, whether you accept but only to save life, whether you want for saving lives or for medical research. You can address those issues as well. You can also address if you are living with somebody in a common law relationship and you have minor children, or if you're married and you have minor children, or even if you don't have children but you're just living with somebody, if you want them to benefit from your property while you're incapacitated, which means if you didn't specifically say in your mandate that you would like a person that you leave, my husband, my children, to benefit from my property, even though I'm incapacitated and I'm unable to live in my house and I have to be moved to a residence. If you didn't specifically wrote that you want to, the law does not presume that you want to, and we have the notion of the public curator that will go to extended means to make sure that the money is used only for the person who is incapacitated and not for anybody else, unless you specifically authorize it in your mandate, which means they can say, and it's happened before, and I've seen cases and I've acted for people in cases like that. If, for example, the man was taking care of his wife who has dementia, she wasn't able anymore to walk. So what he did is he went and sold their house and he went and bought a condo. For some reason, they wouldn't let him buy the condo by himself because he was older and he wasn't working. And what they did is they made him co-sign for the transaction of the property with his son. So the house that he sold was owned 50-50 with him and his wife. He sold it, he took all the money and he bought a condo where he was 50% owner and his son was 50% owner, but using the money that was also the wife's. Here comes the public curator and discovered that he bought a property and did not put the wife's name on the title. And they gave him 10 days, 10 days to rectify the situation, to remove the son altogether from the title and put the wife's name in it. Otherwise, they said that they will go and sue him. Sue him for what? For him to return the money that he earned from the sale of the house that belonged to his wife, the 50% of her share, and put it in a special account that they can access to make sure that this is going to serve for that woman and for her purposes as long as she's alive. Now he started to claim to them, but look, she lives with me. I didn't even put her in a residence. She has care around the clock. I pay caregivers. I took her with me. The only reason why I bought the condo is because it had an elevator and it was easier for her to move around with her wheelchair and the walkers when she needed to use walkers. And I don't understand why you do this to me. There was no one to argue with. That's the way it was, and that's the way they made it seem like there's no other choice. And there was no other choice for him, so he came to us and we helped him move the title. His son had to transfer his share to his mother, and that's how the public curator backed off. So it's always good to have a mandate where you wish to have something happen and you expressly say what you wish for to happen, and you say, I'm allowing my husband, my wife, and my children, as long as I'm alive, even if I'm incapacitated, even if I can't live with them, I'm allowing them to live with their other parent in the house and enjoy my bank account, enjoy my property, and this is what will make the public curator not come on to your case. As far as I'm concerned, I don't have anything to add about the mandate. I usually do it with questions and answers, and there are many, many questions that people answer. People ask, some people answer from experience, some people wait for me to answer. So I don't know if you want to write any questions down below. I will be very happy to answer anything that you may have. I can also tell you that in Quebec, in recent years, there is the advanced medical directives. The advanced medical directives are directives that respect the end of life care, which means the most of the population call it assisted death. It's not really assisted death, but the law said that if you find yourself at an end of life situation and you're either suffering from a terminal illness or advanced dementia and you're dying, or advanced Alzheimer and you're dying, it's not just you have Alzheimer or some forgetfulness, or you were just diagnosed with cancer, but you're not terminal yet by any means, that you can do that, but only if the doctor said that you're palliative and there's nothing that can be done for you. Then you can choose to accept or refuse a few treatments, such as being hooked up to machines, such as being fed by artificial devices, being hydrated by artificial means, having cardiovascular resuscitation, having dialysis. If you refuse all of them, then when you're palliative, if you can talk to by yourself and ask for end-of-life measures, or if you can't talk, then your mandatory can speak for you and ask for it. This advanced medical directives that you sign is attached to your Medicare card, and people who come to me, I make sure that they understand what they're signing, and once they sign, I give personally a notice to RAMQ, and it's attached to your Medicare card, and I make sure it was registered in their computers and systems. Now, this is not to say that if you sign those advanced directives and you fall on the street the next day because you were hit by a bus or because you had a heart attack, that nobody will give you resuscitation. They will give you resuscitation. However, if by the time they found you, there was no brain activity and you were down for a long time, and the only way they could get your pulse back is by hooking you to devices, they will basically tell the family that the person is brain dead, and do they really want to keep him alive on ventilators and artificial means if that person signed a deed that they refused all the treatments beforehand. They will pull up the records and will show the family. So this is something that more and more people have decided to sign recently, and they will use it per their discretion. I had a few clients who decided to use it and who decided that they were palliative. The doctor said that they were palliative, not them. They decided that there's nothing that could be done for them. They tied up loose ends, and then they checked themselves into the hospital, and they waited until the doctor administered the injection to put them into sleep, and they just basically did not wake up from that sleep. If you change your mind at any time until you were administered, it's okay. You can always change your mind. I have many clients who signed it and decided not to use it. They decided to die of a natural death at the hospital or at home. They just wanted to have it in case they decided that it's something that they would like to do. But if you're the type who says, I don't want to be hooked up on machine, unplug me, I don't want my family to see me like that, this is something you may want to consider. The last thing I can speak to you about before we end, unless you have any questions, is a power of attorney. I just wanted to explain to you that the power of attorney is not the same as a mandate in case of incapacity, because a power of attorney legally happens at the same time for two people. So if I give my sister or my brother or my husband a power of attorney, both of us can act at the same time. So I can be at home and not feel like going out because it's snowing or because I broke my leg or because I just don't feel like it, or I'm away somewhere and something needs to be done with my property, whether it's payment of taxes or going to the bank and deposit a check or write a check on my behalf and send it somewhere. But I can't do it, I don't want to do it, or I'm not here to do it, then the person I appointed as my attorney in the power of attorney can do it for me and on my behalf. But if I lose my ability to revoke that power of attorney, which means if I have some kind of a disease like Alzheimer or dementia, and I'm no longer able to say, oh, I would like to revoke it, then technically and legally, the power of attorney ceases to exist. And that's when the mandate has to start being homologated and be used. Because if the banks here, and often they call the client saying, oh, you know, your husband, your daughter is here, they want to take money, it's a very large amount, are you okay with it? And you say, oh, it's Wednesday today, and you answer completely irrelevant to the question that was asked, they will have their suspicions that maybe you're not able to answer legally, and maybe you did lose your ability to act, to your ability to make decisions, and they will block all the transactions like they should, because the law says that the moment a person can no longer make decisions like that, the power of attorney ceases to exist, and the mandate in case of incapacity has to be homologated. That's my information that I wanted to share with you today. Somebody is writing a question about the average cost of a will. So a simple will where you leave everything to your spouse or to your children, and that doesn't require setting up a trust or something more complicated. In today's term, with me, every notary charges differently. With me is $500 plus tax and disbursements. There's registration fees that we need to pay the Chambre de Notaire to register. I am obligated twice a month, even if I didn't write any wills, to report if I did or didn't, and if I did, who wrote a will with me. I give notice with your name and social insurance number and address that on this day you appeared before me and you signed the will. I keep the will forever in my safe, and the clients always get, it's not just the will, it's a mandate. Every other deed I do, it's the same thing. The clients always get a true copy with my signature and my seal. There's a central registry for wills and mandates that I'm obligated to give notice twice a month. And whenever I give a notice, the Chambre de Notaire charges me to register it. So that fee goes back for the person that I did the deed for to pay. And if something happens to me and for some reason I stop practicing, the Chambre de Notaire will always make sure that my deeds are transferred either to the court so people can trace them back, or to another notary so that notary can issue copies if somebody needs to find their will afterwards. Is there any other question? I'm going to wait a few more seconds just to see if there are any other questions. I'm not sure if they are or not. All I can say is that if you think that you wanted to ask me something but you forgot, or you would like to ask me something in private, not in front of everybody, you're welcome to always contact me either by phoning my office. The number is 514-852-5707. You will find also the number and the address in the link I wrote before to my professional page, Liat Levari Notary. You will find there a lot of information that I keep writing from about every week. Every 10 days, I post about different aspects of the law and things that are related to notarial issues like liquidators, mandates, advanced medical directives, wills, divorce in agreement, different things that I write at different times. And also you can find my contact information and a way to send me a private message there that I will try to answer. Are there more questions? Okay, I think, thank you very much, Sean. Very happy to hear that. Thank you, everybody, for joining me. If I noticed that some people said they will come, could not have come, I hope that they can watch this after the feed ends. I think it still stays in the group, so they can rewind and watch it at their will. And if you would like to have another lecture, we can set it up and have another um, live Facebook broadcasting, or maybe even a frontal lecture in somebody's house or in a community center or a library or something like that. So thank you for joining me. I hope you were able to benefit from this lecture, and I wish you all a very good evening. Have a nice day. Bye.